Alex here with a high conflict child custody video on abuse and neglect proceedings. I'm not going to go into the general abuse and neglect term. I'm not going to talk about like any random court case where abuse or neglect is a topic. What I'm actually going to talk about is a specific type of case in Nevada, at least, and probably it's in a lot of other states. It's a specific type of case called an abuse and neglect case or abuse and neglect proceedings. And it's not a case that is instituted by parents. That's the child custody case or the divorce action. Rather, it's a case that's instituted by the government, at least in Nevada. It is. In Nevada, as I mentioned, it's called abuse and neglect proceedings, but other states may have a different name for it. For example, Indiana calls them child in need of services proceedings, or C.H.I.N.S cases, C.H.I.N.S proceedings. And they are slightly different. In fact, they're slightly different in an important way. So I'll go over that later. I'm going to go over an example of why people need to understand that abuse and neglect proceedings brought by the government are very, very different from child custody case or a divorce action, which is brought by the parent or a private citizen. Just going to really compare and contrast these. I'm not going to go into the ideology behind them. I think people just need to understand the difference between them, and hopefully from there they'll see why it's not a good idea to think that you can get your custody rights established by an abuse and neglect court. It's just, once I describe the way that the different objective and the different ways that they work, it should become pretty obvious to people, and hopefully people stop doing this, because this is a common mistake people make, and it can really backfire. And in the worst of cases, which I'm going to go over towards the end of the video with one of my examples, you can find yourself living in a nightmare, just like, what the heck is going on? Because you just don't understand what's going on with the way that the proceedings work and the objective of the government and all of that. So anyway, now I'm just going to get into it. With a child abuse and neglect case, CPS, Child Protective Services, or the Department of Family Services, the agency may have a different name in your state, basically has received an accusation from somebody over the phone, a report, and they've substantiated it, and they basically have removed a child from a parent's home, temporarily, initially at least, to determine whether the child is or is not being abused and neglected. And if so, the child is placed into foster care, at which point the government has to come up with some kind of permanency plan for those children. The permanency plan typically favors reunification with the abuser or neglector, and if efforts to reunify the child with the original parents fails, oftentimes the government will try to terminate their parental rights and adopt them to another home, or award permanent guardianship to like grandparents or something like that. That's not as common. But anyway, as you can see, nowhere in this process, nowhere in that statutory scheme is anything about child custody discussed. It's not. It's a very strict, specific process, um, and some of the parts of that process can actually come out to bite you in the end. One of those is the fact that the parent has a right to um, better themselves or correct whatever abuse and neglect they were committing on their children. Um, the parent has a right to uh, the state services to figure out, if they can be retrained or educated on what not to do to their kids. And there's also a plan. The government has to put together a plan that that parent can accomplish, reasonably accomplish, and that if successful, uh, the government can basically move forward with reunifying the children with those original parents. I don't think that many people have a problem with this when it comes to two parents who are together. When two parents who are together have had their children taken away from them, most people get behind this, because most people understand that foster care is a terrible, terrible place to put kids, comparatively speaking to a home that involves where their natural parents are. Again, comparatively speaking being the phrase. Nobody's saying that foster parents are bad parents. It's just compared to the natural parents, there's less likelihood of some kind of issue. The parents are taking care of their kids because out of the love of their hearts, not because they're getting paid a monthly stipend. I know some foster parents do it out of the goodness of their heart too, but I mean, the thing is that sometimes more abuse and neglect occurs in foster homes, and so most parents can get behind the idea of not severing parental rights and not erasing a parent from a birth certificate and replacing their name with somebody else and shipping the kids off to another home. That's a great alternative when the original parents just can't get their act together. You know, if they're murderers or or criminals or drug addicts or whatever the issue is, if they can't get their crap together, for lack of a better phrase, people can get behind the idea of foster care and adoption. But most people understand that they should at least have a chance to get themselves back up on their feet and to get their kids back. Most people agree with that. The problem is when the two parents are split up. When the two parents are split up and a child abuse or and neglect case opens, most people don't understand why that's not treated differently, why the government can't just step in and just give the kids to the other parent. The problem is there's a whole other cluster of caveats involved with this. When the government is involved in trying to deprive somebody of their fundamental rights, the government has so many more resources at its disposal. And so these different protections trigger. For example, the clear and convincing evidence standard triggers. Um, um, for example, the abuser or neglector the accused abuser or neglector is entitled to a free attorney if they can't afford one. This is very different from a child custody case or a divorce action. It's just uh, when you try to involve the government in your child custody issues, it becomes incredibly complicated because they have a very different agenda, and they have a much tougher burden of proof, and it just ends up involving a different type of analysis because the government is looking to give your ex, if you're from your perspective, if you've involved CPS, the government is looking to give your ex a chance to get better. The government is going to give your ex a free attorney. I mean, the system is not conducive to awarding custody because the system is more, it caters to the abusive or neglectful parent. It really does cater to them. It tries to work with them. It tries to help them get better. And sometimes that means the child is going to get abused or neglected even more, at least because the other parent didn't know that they should have opened child custody proceedings and litigated a child custody case using the completely different process, applicable laws, standard of proof. Everything is completely different in those types of cases. And anyway, now that I've described the way child abuse and neglect proceedings work, I'm going to go ahead and really briefly describe the differences with a child custody or divorce action where there's child custody rights involved. Number one, nobody gets a free attorney. That's because the government isn't stepping in to deprive you of your parental rights. The government is stepping in to mediate how your parental rights should be divided up between the two of you. Some people argue that it's the same thing because my ex is saying that I shouldn't have custody of the kids. It's not the same thing. If your ex is alleging that there's all these issues with you and you shouldn't be able to have primary physical custody of the kids, also known as residential custody, first off, that's not the government, that's your ex. And second of all, the argument that you're not fit to have physical custody is completely different from the argument that you're not fit to have any parental rights at all. Those are very, very different arguments. It's a completely different thing. So there's no free attorney involved. The clear and convincing evidence standard is rarely used. It's mainly going to be preponderance of the evidence throughout the entire case. There are some exceptions. For example, if you want to see one exception, watch my video on, what is it under? Domestic violence. In Nevada, if you're going to accuse your ex of domestic violence to get physical custody, you actually do have to prove that by clear and convincing evidence. It's one of the exceptions. And the third issue is that there is no objective to reunify the parent with an abuser. There is no catering to the abuser's needs. Rather, there is a list of best interest criteria, a list of factors that are articulated in a completely different statutory scheme. Instead of under the abuse and neglect scheme, you're going to be under the parentage scheme or the child custody scheme or under the divorce. It's going to be in a different chapter. And in that chapter, it's going to have a list of criteria that the court must consider. And they basically amount to what's in the best interest of the child. And in those proceedings, it's very different. The objective of the court is to analyze which of the two parents is fit to have physical custody. And if one is not, to place the children with the other. It's an apple and oranges comparison. This is why I tell people, child abuse and neglect cases are not custody cases. Do not rely on them, because the goal of the caseworker and the government is not to give you custody of the kids when so many people think it is, and it's just not. So I'm going to go into that terrible example now. where this person had an ex. His ex was accused of abuse and neglect. I don't know if it was from him or somebody else. The Child Protective Services substantiated the claim, took the child or children away from the mother temporarily. A court case came up to determine what the permanency plan was going to be. Father had a lawyer. I believe he did have a child custody case open, but his attorney was really pushing that he should just let the government just take the reins. The problem is that his ex got a free attorney, and that free attorney argued correctly that she should have a chance to get some access to state services and better herself. And pending that, the children should be returned to her. And the judge was frustrated, but he did agree that that was the law in those types of cases. And so the children were returned to her. And it's a really sad situation because the father had a psychologist who was on his side who had diagnosed his ex with narcissistic personality disorder. The father had a caseworker on his side who wanted the children to be placed with him. And the father had a parenting coordinator kind of on his side who wanted him to have joint physical custody, which was a step in the right direction because at the time his ex had primary physical custody. And none of that happened. And this guy was so frustrated. He was like, what's going on? Why would the judge do this? My ex has narcissistic personality disorder. She has serious mental health issues. All these experts are saying he needs to change his situation. What happened? And I told him, was it a child abuse and neglect case? And he said it was a C.H.I.N.S case, which is, as I mentioned earlier, it's a different name for almost the same thing. And I said, well, that's why. Because in the statutes, there's nothing in there about awarding custody. A parent who's been accused of abuse and neglect does have a right to better themselves. The judge followed the law. And so I questioned him as to why he didn't proceed under his child custody case and divorce action. And he said it was because his attorney recommended not to. And this is kind of when I face-palmed, because I was like, the attorney should know that the objective of a court is very different in these cases. The attorney should not have said that. Anyways, it turns out after this parent went and did research, it turns out his attorney didn't know any of this. And when he presented the research to his attorney did switch gears. And everything is appearing to get on the right track now. It's a little startling that the parent had to go and do the legal research for the attorney. But if you want to watch my video on settlers versus litigators, go ahead and watch that and find out why this can and does happen in child custody situations. And even non-child custody situations. I just think it's that the family courts and family attorneys, the situation it's rife with this kind of problem. So anyway, with that, I think I'm going to go ahead and end this video. If anyone has any questions or if anyone else has gone through this, oh, one more thing before I end this video. In Nevada, abuse and neglect proceedings run parallel to child custody cases or a divorce action. There are some states that are very different where the child abuse and neglect court or the C.H.I.N.S court will ask you to consent to the child being a child in needs. This is not a good thing. This is not a good idea. What they're basically saying is that you need to consent to your child being a child in needs because you, the non-offending parent, are not able or willing to take custody of that child. My understanding is that if you consent to this, you cannot proceed in your child custody or divorce action while that C.H.I.N.S action is pending. You are effectively locked out of using the normal child custody process to get custody of your kids until the child abuse, the C.H.I.N.S proceedings are resolved. Based on the research that I've looked at and what the other parent has presented to me, it looks like that is exactly consistent with what happens in certain states. So be very careful if you're in one of those states of consenting to that. The case law that parent brought to my attention basically stated that a parent can show up at a C.H.I.N.S proceeding and state that my child is not a child in needs because even though my ex abused the child, I am not with her anymore. And I am capable and willing of taking care of my own child, and I will prosecute this action in a child custody case and protect my child. That's exactly what they stated in a bunch of the case law that he brought to my attention, and that is a valid basis to deny, to basically close out a C.H.I.N.S court, to basically close out an abuse and neglect court, and I think that makes sense. If there's another parent who's willing to take care of the kids, that child is not a child in needs. That child should just be placed with that other parent. But of course, that parent is going to have to show up and tell that court, I'm going to fight for my child. I'm going to go and get a custody order. I'm going to protect my child. and they're going to have to be convincing about it. Now, as I mentioned, this is only some states that do this. In Nevada, both cases just run at the same time. So there can be an abuse and neglect case open, and there can also be a child custody case open at the same time. There's no problem with this. Both cases just run, and one could close before the other and whatever, and you can use the findings in one court and the other and all that. So anyway, now I'm going to go ahead and end this video. If anyone else has gone through this, please go ahead and put down in the comments below, because I know that it's a very common mistake people make to involve child protective services, thinking that they're going to somehow get them custody of the kids, and that's just not how it works. With that, I'm going to go ahead and end this video, and I'll see you guys next time.